to ensure that we put into cognizance the environmental impact of an activity before the activity takes place. It's a principle that was borrowed from United States of America, which has received a global attention. And it has also been incorporated into our own law by virtue of Environmental Impact Assessment Act 1992. We shall look into the details of how that can be done. We'll look at the decision to be taken before EIA is done, the objective of the EIA, when is EIA necessary, when is it significant, what kind of project do you require before EIA is done, the timing to submit the EIA processes, the EIA review process after submission of report, and the role of the public in EIA matters. And after that, I don't think there is any other thing to be done. Perhaps when it comes to that, we can also look at the post-EIA submission review by the agency. And then who has the authority as between the Federal Ministry of Environment and the National Environmental Standard and Regulations Enforcement Agencies to regulate EIA? And what is the practice? What is the law? And what is the practice? Please, can you just hold on for me? I'm back. Environmental impact assessment and related procedure has been identified as one of the key mechanisms that we use to translate the principles and criteria of sustainable development into practical steps, strategies, and action. This principle was recognized first at the 1992 Conference on Environment and Development and Agenda 21, as well as Principle 17 of the Rio Declaration. What do you mean by EIA? There is no universal consensus about the definition, extent, and scope of what EIA means, but it has been generally accepted to mean the examination, the analysis, and assessment of planned activities with a view to ensuring environmentally sound and sustainable sustainable development. It is a process of identifying, predicting, and evaluating the possible impacts of both beneficial and adverse alternatives and mitigating measures with a view to eliminating or minimizing negative impacts and optimizing positive impacts. Now, let me break all this English or grammar that I've been speaking to you in simple terms. A project proponent wants to undertake a project. let's say he wants to construct a factory. In that factory, they are going to use some chemicals. In that factory, there's going to be wastewater. In that factory, they are going to employ a lot of people. Siting the factory will require that they will require land. And some of these residues of the industrial product has to be discharged. Where would they discharge it? How would they discharge it? If it is discharged, is it likely to cause environmental hazard? Is the production process likely to endanger the people around the vicinity or many kilometers away? What are the beneficial impacts of that project, as well as the negative environmental impact on the people? This is the basic problem of basic business of EIA. EIA enables you to take in advance, to look into the future, holistic view of the entire project life cycle. Therefore, allowing you not only to take into consideration the cost and the benefits of the project, but also internalizing the environmental cost, which may arise now or in the nearest future. And how do you do it? Environmental law or environmental policy does not say you cannot engage in development. But if you are going to engage in any development, the development must be sustainable. In other words, you have to integrate those environmental considerations into your planning decisions. If you know that that project has a lifespan of 10 years, you have to put the cost of the commissioning. What kind of chemical will you use? When are there other alternatives other than the present one that you intend to use? And if you are going to do all those things, what are the mitigating factors or things that you must put in place, assuming those environmental harm do occur in future? And do you need to set aside some fund by way of insurance, by way of constant review of your technologies and the processes? This is what EIA is all about. Analyzing, predicting, and determining both the economic and the environmental impact of a proposed activity beforehand. Whether it's going to happen or it's not likely to happen, EIA must be undertaken. This is part of the ways by which the world tend to minimize the environmental impact that, or reduce or totally eliminate, if possible, certain environmental harm that may arise from developmental projects. And it is not every project that you require EIA. The law prescribes the process. We'll go there one by one. But if you understand what EIA is all about, policymakers or governments or laws does not necessarily say you should not engage in development. Every development activities we are going to undertake, we have one way or the other some environmental consideration. Putting that into consideration beforehand. In other words, a station time saves 9. That is the concept behind EIA. If you remember, we talked about precautionary principles in our early discussion. EIA is the practical translation of precautionary principles, the theoretical principle of precautionary principle into realities. So it's one of the key components in environmental management and sustainable development. And in the process of doing that, EIC also serves as a means of gathering of environmental information, which ultimately serve to inform the government decision makers about the environmental consideration they should take into account before authorizing a development activity, or to identify and analyze ways in which the benefit of an activity might be maximized, and also to identify and analyze measures for mitigating an activities likely to cause environmental effect. and therefore ensuring the sustainable management of natural resources and the prevention of environmental degradation. This is what EIA is all about. The heart of EIA process is the analysis of alternatives. When they say go and do EIA, the EIA wants you to know, well, I'm going to do this, likely to happen. If this is going to happen, do we have alternative that will minimize it? And if you don't have alternative, is it wise for us to go ahead? What can we do to mitigate it, to reduce the impact? Not necessarily that the project should not go on. Now, what are the legal framework for EIA in Nigeria? The legislative regime for the regulation of environmental impact assessment of projects in Nigeria is contained in the National Urban and Regional Planning Act of 1992, which is in relation to physical planning. But in relation to a very large project, the main legislation is the Environmental Impact Assessment Act, 1992. Environmental Impact Assessment Procedure and Environmental Guidelines are standard for petroleum industry, applicable only to oil industry, as well as the procedure formulated by Federal Ministry of Environment on EIA processes and procedure. Those are the laws that regulate environmental impact assessment in Nigeria. Now, what are the basic objectives of the EIA? The basic objective of the EIA can be found in sections 27 and 32 of the EIA Act. Section 1 of the EIA outlines the most fundamental objectives of the EIA. 1, the establishment of significant environmental effect of any project to be undertaken by any person, authority, corporate bodies or incorporated bodies, including the federal, state, or local government. B, encouragement of development of procedures for information exchange, notification, and consultation between organs and people when proposed activities are likely to have significant transboundary effects. 3, consideration of environmental factors in addition to economic, technical, and political consideration. Enforcement of administrative transparency and accountability by requiring that the assumptions and judgments made in arriving at decisions are more explicit. The very basic principle of objective of EIA, first of all, EIA is an environmental information. That information proceeds from project proponents to the decision makers. They know you are the one who wants to do a project. You are the one to provide the necessary environmental information to decision makers, in this case, Federal Ministry of Environment or NESRA, to determine whether or not that project should be approved. So, it takes into consideration environmental factor, apart from the cost and benefit of political consideration, which is the basis for which most projects are being undertaken before the introduction of the EIA. Ability to bring out to describe and bring out the residual impact that cannot be mitigated. The EIA must also reveal some of those impacts that are not likely to be mitigated. For example, a lot of people are talking about Dangote refinery and the production of ammonia. There are many environmental harms, both to manhood and to everything, that can never be reversed. If happen, they can only be minimized or be prevented. So everybody knows that the production of petrochemical is not only dangerous to the immediate environment, but also has transboundary effect if not properly controlled. And so, in doing that, the EIA of the proposed project will have revealed substantially, if properly done, some of these adverse environmental impacts, the negativities, and how those things can be minimized or maintained. Now, what are the threshold decisions that a project proponent must undertake under the EIA Act? The first thing a project proponent must do is to identify the project that is about to be taken. This includes preparation of feasibility studies that will reveal possible alternatives, cost, location, as well as the scale and dimension of the project. But not oftentimes every project requires EIA. It is not every project that requires EIA. Before a decision can be taken by a project proponent, whether it is relevant for him to undertake an EIA or otherwise, the project proponent must satisfy himself with 3 basic questions, 4 basic questions. 1, whether EIA is applicable to him. 2, must he prepare a full EIA report or something else? 3, if a full EIA report is needed, what must it contain? D, and at what stage must EIA be prepared? Now, if you're a lawyer advising a client as to EIA, the first question you ask yourself is, what is a project? Is the person undertaking a project as expected under the EIA? Now, the definition of project in section 2 is very clear. It refers to any physical work that a project proponent decides to construct, to operate, to modify, to decommission or abandon, or the carrying out of any physical activities that the project proponents propose to undertake or otherwise carried out. So, any project, anything that is have to do with physical work, which involve construction, operation, modification, decommissioning, is called a project. And so that project, the next question you ask yourself is, are you one of those entities regulated? Yes. Check the law. Every project, whether owned by government or non-government organization, are subject to EIA regulation under sections 2, 14, and 64. But where your project was not listed as those to be subjected to EIA, then you will not require, EIA will not be required from you. I want you to see the case of Baytide Nigeria Limited, Baytide Nigeria Limited against Aderinokun. Aderinokun is reported in, what's a minute, let me look for them. Please hold on, let me look for the citation for you. In 2014, 4 Nigeria Weekly Law Reports, part 1396, at page 164. 2014, 4 Nigerian Law Reports, part 1396 at page 164. When will EIA be necessary? When is it that you will require to do an EIA? It is important for you to know that it's not in all cases that when the project is conceived, an EIA must be undertaken. No. An EIA will only be necessary if the proposed project will have an impact on the environment. And you know the meaning of environment. And when you talk about impact, it is not only environmental, it also includes social and economic impact on the society. You can take a look at the case of Hanley against clandestine Hanley 1, which is reported. The citation you can find at page 812 of the book, of my book. It's a very long citation. You can also see the case of Metropolitan Edison Company Limited against People Against Nuclear Energy, PAIN, where the Supreme Court of US took the position that environmental effect also includes human health, which must be taken into consideration, but they must not be too remote or very speculative. It must be something that is actual, not something that you are speculating. The question is, I've said that it is not every project that requires EIA, but by our law, projects that are likely to have significant or serious environmental impacts on the environment is required by law to have an EIA. Section 17(1) of the EIA. What do you mean by significantly affect the environment? The phrase is not defined in the Act. It is for the way to find whether your project will significantly affect the environment is contained in the mandatory list of the EIA procedure. Some projects are especially stated there that anytime you want to undertake those projects, you must undertake an EIA. You must take an EIA project. EIA. You must undertake EIA activities. I want you to take a look at pages 184 and page 1 and 815 of my book to understand what constitutes significant project. And then if you take a look at it further, the projects, or you can take, if you can see the EIA regulation, next FEPA EIA mandatory list, I also stated it in page 816 to 817 to up to page 817. It talks about those projects that requires the EIA mandatory list, projects in eco-sensitive area, non-mandatory, but which are within category 2 and 3, that they do, even though they are not deemed significant, but because those projects were implemented or established or are likely to be established in the environmental sensitive area, like marshy area, wetlands, swamp, islands, slopes, you will, or conservation area, the project will require, the law requires you to undertake EIA, full EIA, and not minimum. When is the timing for EIA? When a decision is taken that EIA is necessary, the next step is to determine when an EIA is to be prepared and the scope of EIA to be undertaken. Usually, the project proponents are faced with decision dilemmas to what stage. There is no hard and fast rule about when EIA is to be undertaken. But one view that is generally accepted is that it should be integrated into the project at the earliest possible time, at the formative stage. And so the act does not specifically state this is the step you should take, this is the first step, this is the second step. But in practice, project proponent consult with Federal Ministry of Environment, which is the authority that is undertaking those things. What are the EIA processes? One, submission of project proposal, screening. The second step is to screen whether your project falls within the EIA, whether you are going to do full EIA or partial EIA, and the state, or whether your project falls within category 1, 2, or 3. When you have done that, you have to select your EIA team, which in most cases consists of the experts. Most people don't put legal consultant, and they meet their problems. But when it comes to analysis of those or internal review, apart from the technical people, the legal people will look into whether the requirement of law is complied with. But in Nigeria, nobody does anything. 2, the next step is scoping. Scoping is done by the project proponent or by its consultant in order to identify and narrow down the potential environmental impact, with a view to ensuring that the assessment focuses on the key issues, not just any environment. You narrow the environmental impact to a certain level. Then after that, you write your report, which you will submit to the environmental regulatory authority. There have been a problem as to who has the authority to regulate EIA. The NESDA Act vests the responsibility on NESDA, but the Federal Ministry of Environment usurped the functions of NESDA, which was a subject of litigation between NESDA and a state agency that went ahead. The Court of Appeal in NESDA against Kaduna Environmental Protection Agency clearly stated that it is only NESDA that can undertake the functions of environmental impact assessment as the only regulatory agency. But despite that decision, the Federal Ministry of Environment continued to exercise that power illegally. And because NESDA is an arm of they cannot regulate their way out. So as of today, it is the Federal Ministry of Environment that continue to exercise oversight functions and become the approval granting authority on EIA, despite the Court of Appeal decision to that effect. Let me see the citation of that case, NESDA against Kaduna. I can go and read it. Remind me, I'll give it to you later. Let's just proceed with the lecture. Now, one key aspect of EIA is public participation. Once an EIA report is submitted to Federal Ministry of Environment, there will be publications in the newspaper requiring general public to comment as to the impact of that project. They will publish it, you go to the place, you read it, and raise oppositions. The essence of public participation, which is contained in section, I think it's section 7 of the Act, is to inform and consult the general public in respect of the project evaluation, identification, and compliance with the EIA process. General public are expected to voice their opposition, but public opposition to EIA report must not be based on emotions, political sentiment, or personal idiosyncrasies, or sensitivity to the project, or hatred, but they must be able to establish a clear nexus of actual or threatening environmental harm to the general public or public health in terms of outbreak of epidemics, infectious disease, contagious disease, genetically modified related disease, or any impact that the project may cause to the economy or to the human health. Most people will go there, and do you know why Nigerians always fail in EIA, not opposing the EIA? Because they don't put money. A Shell is proposing to do something. They just go and call one local person and didn't pay him well. How is he going to look into the EIA projected by Shell? So if you want to challenge the project by companies, particularly multinational companies or even bigger companies in Nigeria, you need to employ competent experts that will look into those EIA and critique it and come up with alternatives. Most CIA reports are baseline information. People just go and copy another person's work, do it back, and submit it. No meaningful contribution, no proper review, and the project will go like that. Now, when else do we have environmental class? Class governor, when else is our class on environment? And what time? Hello? Can you hear me?
Yes, we can hear you, sir.
Next week, Thursday.
Next week
Thursday, sir.
Next
Thursday,
week,
yes, sir.
Yeah, Thursday.
From the timetable, when are you supposed to move in? When are you moving for your exams? Year 4.
I think year 4 or year
Yes.
3. It should be, I think, February 15th.
Year 3 is coming in February from the timetable. Yeah, this is a year 4 course.
Sir, it's March for year 4 student.
Okay, yeah.
No, year 3 is doing it now.
There is March for year 4 students and February for year 3.
It's both year 3 and year 4?
Yes, sir. Yes, sir. There are 3 students doing the course, sir.
There are some.
But it's mainly a year 4 course.
Okay, but
there are
year 3 students are offering the course.
Yes, sir.
Then we have to move for. Because I want to stop here. I want you to go and read chapter. What's that chapter? Go to the library if you have the book. Read chapter 13 from page 821 to page 832. I've covered enough ground there that if I move forward, I will just be loading you with so much information. At the next class, we will finish the EIA, and then we'll move to, because of the examination coming next week, Thursday. And then we can move into damages. If time permits, we go back to chemical management. Do you have any questions for me? Class, do you have any questions for me on EIA? Solomon.
Sir, how are we now going to sort the exam?
Hello, good afternoon, sir.
Good afternoon.
Yes, sir. For
Good
the
morning.
exam, sir. Good morning, sir. The exam, sir, is it going to be like we're going to wait for year 3 students? We're going to come in
to write with year 3 students, or to write with year 4 students, or year 4 students to write with year 3 students for
Please
the
take your
exam, sir?
complaint. Take your complaint to the dean. My own, I'm just a lecturer. Once they fix the timetable, I don't get myself involved in timetable or who and who. My own, I'm a lecturer.
About the test.
I will teach you. I will set the exam, and I will test you. Wherever we stop, that is where you will see your question. But I can assure you, if year 3 is going to offer this course, we have to finish. We can't have 2 exams for year 3 and 1 for year 4. The exam has to be done the same time. Perhaps what is going to happen is that if we have to look at the total number of students, the class governor should try and see. The class governor should try and see the dean and discuss this issue.
Okay, sir.
So, on that note, ladies and gentlemen, if you don't have any questions for me.
How about the test, sir?
The
test?
You say what?
The test.
The test. Please liaise with Professor Tubu on the test. I'm a senior professor. I don't get myself involved with the test. Liaise with Isa, who's the other guy? This Ibrahim. Liaise with Ibrahim and Professor Tubu. They will tell you when to have the test and the mode is going to take. The mode is likely to be. Is that clear? All right. Have a nice day. Go and read your book.